Good morning. I'll add my own welcome to all of you, particularly those of you who are alum. Welcome back. It's so nice to see all of you, and to all of the students who are here. It is a Saturday, at least for my water law students. The hope is that by being here this Saturday, there will be a canceled class later in the term. So I hope it's worth it for you. I would like to, just for a second, have the members of GEL stand up so we can just recognize them along with Brian and Shannon, but all the members of GEL stand up. And if we could just give them a round of applause. So my talk today is on balancing hydropower production and dam removal in the United States and the ushering in of what I think most commentators believe is a new era in hydropower and dam development in the United States. I hope through the talk that I'm going to give, you'll be able to understand the basics of hydropower production in the U.S., and in particular the legal and the regulatory structures for the various kinds of hydropower facilities that we have in the United States. And the reason I think that this is important is that, one, it'll help as I then move into describing some current examples of dam removal projects. And it is that very legal and regulatory structure that I believe provides the framework in which dam removal has happened in the United States. And then finally, I want to spend some time just understanding the role of the Federal Energy Regulatory Commission's relicensing process, and in particular, its relationship to river restoration. And I'll do that in the context of talking about the Klamath Basin in particular. And compare FERC's process to the dynamics on federally owned, and I think this will all make sense to you in a minute, federally owned or state-owned reservoirs that are not subject to FERC's authority under the Federal Power Act. The Federal Power Act is one of my favorite statutes to teach, particularly to, that's crazy, huh? Particularly to law students who imagine themselves saving rivers. Because I'm not sure they believe before they come to law school that a statute called the Federal Power Act might be the key to restoring Western rivers. And so it's this fun moment of sort of understanding how the law and regulatory structure can have these interesting twists and turns in it. And I think the story of the Federal Power Act is really that story. So just to start, let's talk briefly about water power. Pretty easy. It's energy derived from falling water, and it has roots deep in American culture and history, and particularly the advent of the Industrial Revolution. So it begins with the simple water mill, where water turns a paddle wheel attached to a drive shaft, and that is attached to machinery, and you're able to produce something and make energy. And then it moves in, particularly around the time of the Industrial Revolution, to the mill dams. That are used to create a head of water in order to create more falling water, more stored energy, and that energy is available to create hydropower and really emerges at the advent of the Industrial Revolution. Many dam removal projects in the United States that are outside of the Federal Energy Regulatory Commission's jurisdiction occur in the East around these kinds of facilities, these mill dams. That may or may not be regulated by federal or state law, that are often privately owned, and there's a whole regulatory structure that applies to these. But when we start talking about the numbers of dam removals that have taken place in the U.S. In the last couple of decades, a lot of them are facilities that look like this in the East. But then water power takes an interesting turn with the development of the turbine. And that has ultimately enhanced our ability to use water to generate electricity, and brought us the modern hydropower energy industry that we know today. The image at the bottom, of course, is Grand Coulee, the largest hydropower production facility in the United States. The advent of the turbine created the landscape where we could develop in the United States a clean, green, low carbon footprint source of energy. And folks may disagree with whether it's clean and whether it's green and its carbon footprint, but you have to account for how hydropower compares to other energy sources and their carbon footprints in the United States to understand the dynamics around which dams come out and which don't. Hydropower has its advantages as an energy source, and they're well documented. It's cost effective. Many of us in the Northwest enjoy very cheap power because of the presence of hydropower. Clean and green, has a lower carbon footprint than many other sources of energy, particularly when you look at something like coal, energy produced from coal-fired power plants. It is renewable in the sense that it is dependent on the hydrologic cycle, and it comes around, with the water. We have water each year. It's stored in reservoirs. We can produce energy from it. There's a renewable character to hydropower. And most importantly, in the advent of the renewable industry, I think, is that it's available on demand. So it makes it a really nice gap-filling power for other renewable sources that aren't available on demand, namely solar and wind. So if you put a portfolio together where you have some hydropower, that hydropower can fill in the intermittent spaces where solar or wind might not be available to create a solid source of energy. Of course, hydropower also comes with its disadvantages and its downsides, and those are well documented as well. It's dependent on hydrologic conditions and climate, and for anyone who's followed the dynamics on the Colorado River, the Glen Canyon Dam, which is one of the largest federally owned hydropower, it's one of the largest, doesn't compete with Grand Coulee, but reservoirs. It's been really interesting as the hydrology has changed in the Colorado Basin because of climate change. The dynamics around that dam have changed dramatically. In particular, there have been years where the Bureau of Reclamation that manages that facility have been worried that the water levels in the reservoir in Lake Powell will drop below the hydropower intakes for the hydropower turbines. So one of the downsides of hydropower is that it is very dependent on hydrologic conditions and climate. Another downside to hydropower is we sort of have what we're going to have in terms of the big dam sites. Most of the canyons that are the most susceptible to generating the kind of head you need to have productive hydropower are taken. We have conquered that piece of the West and put dams in most of those spots. So the best dam sites are already taken, or they are now protected from having a dam go in them. Dams also come with long-term maintenance and safety issues. These are massive engineered structures, and they age just like any infrastructure does. And so one of the costs over the long term is the cost to maintaining the structure. And of course, and this will be the focus of my talk today, we're all familiar with the ecological impacts that dams have had in terms of altering our natural river systems in the West, such that the United States today looks like this. So this is an inventory of dams in the nation. Most reports estimate that we have between 75,000 and 76,000 dams in the United States. Each black dot represents one of those 76,000 facilities. So you can get a sense of the concentration. The green shading represents non-hydroelectric dams. So this inventory of dams includes all of them in the United States, even those that don't generate hydroelectric power. So you can get a sense of the concentrations of the non-hydroelectric dams, with the darker green states having the most non-hydro dams, and the lighter states having the greatest concentration of their black dots being hydroelectric facilities. So we have dammed a lot of rivers. We have a lot of them in place in the United States. According to American Rivers data from 2012, to date, we've removed about 1,057 of the 75,000 dams that are represented in this map. And since 1999, 593 of those dams have come out. These facilities largely fall into two categories, and there are some exceptions to this, but they largely fall into two categories. The small, privately owned, like mill dams that I showed you in the first instance, that may or may not be regulated under state and federal law. And then the second category, which I'll focus on today, the FERC-licensed hydropower facilities under the Federal Power Act. Before we get into the FPA in some more detail, though, I want to just look for a minute at the purposes we assign to American dams, because I think it's really interesting. So one thing to note before you look at this is that many facilities are multi-purpose. So, you have facilities that have one or more of these purposes. But you get a good sense here of the ones, at least about 2,259 that fall into this hydroelectric category and are regulated under the FPA. Some are not, if they're on a federal facility, but that's the category we'll be talking about today. Another table I just want to show you, and this is from a Heinz Foundation study on dam removal in the United States, is the ownership of those dams in America. The number that are in private ownership, and those include many that have FERC licenses, but then you have a huge quantity that are not licensed by FERC, they're in private ownership. Local ownership, state, federal, owned by a public utility, and then undetermined. There are a fair number of abandoned and undetermined sort of dam sites in the U.S., dams that we can't figure out who owns them and is in charge. So while the purposes of a dam and the ownership status of a dam are sort of interesting and relevant, from a legal perspective, I think what is really valuable to understand are these three categories, because it's these three categories that set in motion the regulatory and legal structure that can lead to dam removal. So among these dams that are in this ownership status, there are three basic categories. Federally owned and operated facilities, federal and state licensed facilities that are in private ownership, and then privately owned and not licensed facilities in this other category. The contrast I want to draw for you at the end is the difference between these two categories. So many of the large dams that we know from the Columbia River, from the Colorado River, the Snake River, major river systems in the U.S. are federally owned and operated. And those are owned and operated by the Bureau of Reclamation and the Army Corps of Engineers being the two that are the most significant in the western United States. You also have entities like the Tennessee Valley Authority that own and operate dams in a particular region. Those dams are creatures of congressional authority. They are created in federal statutes. Congress has authorized those agencies to operate those dams. And they are not subject to the same regulatory landscape that these federal and state licensed dams are subject to. And on the federal side, it's through the operation of the Federal Power Act and the work that is done by the Federal Energy Regulatory Commission and the licensing and, most importantly, relicensing process that FERC carries out that has allowed us to revisit some of these questions, right? And so this act that is meant to license hydropower and authorize dams to go in fact, because of the way Congress has written and amended that statute, provides the framework in which we can reconsider. The possibility of reconsidering these facilities rests with Congress. There's no automatic mechanism by which we step back and say, is it still cost effective? Does it still make sense? Is this still a good business decision? Is this the right ecological decision with regard to these facilities? These facilities, we actually, through FERC and the Federal Power Act, and then through the state licensing requirements for those under state law, for those facilities that are licensed under state law, we do have the opportunity to revisit these questions. So let's start with an overview, just a quick overview of the FERC relicensing process. I want to look at three examples of dams that have come out. They're famous in the Northwest at this point. They're the reason we say we're ushering in a new era. And those have all occurred in the context of of the administrative and regulatory structure that FERC administers. And then I want to look at the Klamath River and then close with the comparison about why I think the Federal Power Act is so important in this new era. So the Federal Power Act is a great statute. I love to teach it. It applies where a facility is located on a navigable water of the United States For my water law students, you'll come to detest the word navigable, because what it means in the context of FERC is not what it means in the context of the Clean Water Act, is not what it means in the context of navigability for state title. So never has, I say this in water law all the time, never has the law asked one word to do so much. And it makes it really difficult in water law. But for the purposes of FERC jurisdiction, it's navigable under FERC's definition under the Federal Power Act's definition of navigability. If a facility occupies lands of the U.S. or uses surplus water or power from a government dam, one of those federally owned dams, or it's located on a body of water over which Congress has Commerce Clause jurisdiction, that will make my water law students really pull their hair out when we get there. And the project affects interstate commerce. And so these are where we find private entities going to the Federal Energy Regulatory Commission to apply for a license to operate a hydropower facility. The Federal Power Act has a series of provisions that set the stage for being able to consider things like the ecosystem in the process of licensing and relicensing. In particular, Section 4 requires that a license be in the public interest. And that definition of public interest includes the consideration of things like the ecosystem, like the benefits and the detriments that will flow from a facility. In addition, the Federal Power Act imagines that every license will be for a limited time duration. And in truth, I think that may be the thing about the Federal Power Act that distinguishes these facilities from all the others, is that there is a recognition that this is a license for a particular period of time, and that there will be a moment in time when we will re-examine it. And we just don't have that in other contexts. Section 10 of the Federal Power Act requires that a license be best adapted to a comprehensive plan for improving or developing a waterway or other beneficial public uses. That comprehensive plan language and public interest language was expanded upon in a set of 1986 amendments that provided that equal consideration be given to power development, energy conservation, fish and wildlife, recreational opportunities, and the preservation of other aspects of environmental quality. So you begin to see the statutory language and framework through which things like river restoration and that ecosystem can be protected, even though this is a statute that allows for licenses to dam, to put hydropower facilities on rivers. In addition, the Federal Power Act must consider cumulative impacts. And then finally, the other, I think, biggest mechanism through which in this relicensing process we get the consideration of ecosystem values is the condition and prescription authority embedded in FERC. So what do I mean by condition and prescription authority? For those in the room who have lived in the land of Federal Power Act dams, these are very familiar provisions. In fact, lawyers who practice in this area talk about 10A recommendations, 4E mandatory conditions, Section 18 fishway prescriptions, and 10J fishway prescriptions all the time. If you practice law here for students, these will roll off your tongue like you will not imagine once you're in this area. This condition and prescription authority forms the backbone of the substantive considerations that come into play when a dam is being licensed or relicensed, and they come from other agencies besides FERC. This is actually an amazing process. I know it's hard to get excited on a Saturday morning about a regulatory process, but this one is worth your attention, I promise you. The 10A recommendations are general recommendations that can come in from the parties, the resource agencies, other resource agencies in the federal government, including the Park Service, the Fish and Wildlife Service, NOAA Fisheries, and other entities. And it's required that they become part of the analysis of the equal consideration to other resources. So in this very simple way, the FERC licensing and relicensing process creates a way in which people can make recommendations and provide data and input, and all of that bears on a determination that FERC has to make in the context of giving equal consideration to all the factors we looked at earlier. With regard to the 10A recommendations, FERC has plenty of discretion to accept or deny those recommendations, right? They go into the analysis. It's sort of an arbitrary and capricious standard of review. FERC has a lot of discretion. The remaining condition and prescription authority, though, that level of discretion that FERC has changes dramatically. So with Section 4E mandatory conditions, if there are federal reservations of land, that includes any park unit, any Indian reservation, DOD lands, Forest Service lands, on which part of the project are located, and we've litigated what it means to be located, the agencies responsible for managing those lands, not FERC, not the licensee, the agencies responsible for managing those lands, the Park Service, the tribes and the BIA with regard to Indian lands, the Forest Service with regard to Forest Service lands, can submit mandatory conditions on the license. So when the licensee shows up to get their license or they show up to be relicensed, these entities can submit mandatory conditions on the license. Under the Federal Power Act, FERC must accept these conditions. There is no discretion to deny. If the license applicant takes issue with these conditions, they must either appeal to the court or, under the Energy Policy Act of 2005, ask for, in a relicensing proceeding, ask for a hearing around disputed material facts in those recommendations. That's astounding, right? It gives another set of federal agencies the power to submit mandatory conditions on a license that FERC has no discretion to deny. The dynamics around agency capture and agency discretion are completely different here. For those of you who had admin law from me, I hope you can appreciate this is a completely different administrative law framework in which these licenses are granted. Section 18 provides for federal fishway prescriptions and gives authority to the Secretaries of Interior and Commerce to require fishway prescriptions to protect fisheries that are impacted by the hydropower project. So this isn't about whether or not there are federal lands. This is about the fishery resource that is managed by Interior and Commerce. And it's broader than just species. The Endangered Species Act operates with regard to listed species, particular species that are listed. This authority is bigger than a particular listed species. It relates to a fishery, the health and productivity of the fishery, whether or not that fishery is listed under the Endangered Species Act or not. It's the entire fishery. First, FERC must also accept these prescriptions. Again, no discretion to deny. The applicant's remedy is with the court or through this hearing that they can request under the Energy Policy Act. And then finally, the 10J fishway prescriptions, because we're not done. This is a mechanism for non-federal, so you should hear state fish and game agencies, state DEQs, resources, the state parks departments, for non-federal authorities, cities, other kinds of groups, to submit prescriptions. And FERC must adopt these as well unless they're inconsistent with the Federal Power Act. This is the mechanism through which states end up playing a tremendous role in the FERC licensing and relicensing process through the 10J prescription process. If there are questions about these recommendations, there's actually case law that FERC must provide expert agency deference to the agencies that have provided these prescriptions. So even though they're not required to adopt them, they have to provide the kind of deference that we see in administrative law to these conditions and prescriptions. This is actually the mechanism through which many of the state water quality standards are enforced on licenses and relicensing of the FERC facility. In some instances, it depends on the willingness. This one depends on the willingness of the state to sort of fully utilize this authority. So I hope you get a sense that it is through this process that these considerations that are separate and apart from hydropower production, that are about other values that may be operating on our rivers, enter the process. It is through these mandatory conditions and prescriptions that the financial viability of a project gets played out. So what can happen is that if an applicant is applying for a license or a relicense, and the amount of alteration to the project for fish ladders and the release of water for water quality flows and all of that, if it gets too great, guess what happens from the private applicant's perspective? It's not worth it, right? Either the project can be redesigned and viable, taking these environmental values into account, or it can't. And we not only consider this at the point of granting the license, we go through this whole process again on a 30 to 50-year time frame when we reevaluate the license, right? So it's not even a one-time bite at this apple. We come back to it again and again. And I think most people believe that this is actually the power of the Federal Power Act, and it has set the framework for dam removal in the United States. I mean, it is the statute under which facilities are being taken out. And so in 1994, FERC actually issued a project decommissioning at relicensing policy statement, and that policy statement is extremely controversial because it provides that if a project is not relicensed for whatever reason, it must be decommissioned. You have to go through a decommissioning process, the process of deconstructing a facility that's already gone in. And normally, I love the word normally, boy did that get added to save somebody's bacon. Normally, the commission anticipates is another great verb, that the licensee will be responsible for paying the cost up to a reasonable level of steps needed to decommission the project, since the licensee created the project and benefited from its operation. That's astounding, right? Because it means that the cost and the process of decommissioning and taking facilities offline rests with and is related to the work of the licensee. So with this foundation, let's look at some specific dam removal projects here in the Northwest that were the results of the relicensing proceedings or related to relicensing proceedings. The Marmot Dam on the Sandy River in Oregon, which came out in 2007 and 2008. The Condit Dam, where the removal started in 2001. And then finally, the restoration on the Elwha River with the Glines Canyon Dam. So this is the Marmot Dam on the Sandy. And if this all goes as planned, we'll have a little video. This one has no sound. And this is actually the coffer dam that was built, but this is actually when the river is done being dammed. Time lapse, obviously. So the Marmot Dam was part of the Bull Run hydroelectric project on the Sandy River, which drains the northwest slopes of Mount Hood. Portland General Electric held the FERC license for the Marmot Dam and constructed it in 1913. It was constructed in 1913. It supplied about 22 megawatts of electricity. PG&E decided early in the relicensing process to surrender the license and remove the dams voluntarily. PG&E did that because their lawyers and their staff started looking at what was going to happen under this condition and prescription authority, and there was just no way it was going to be a viable business decision to leave this facility, and so they voluntarily surrendered the license. In 2002, the removal efforts began, with PG&E paying the full cost of complete removal of the dam and the diversion channels, about $23.7 million. And then in 2008, the final steps of the dam removal took place, which you saw here. So that's one example here in the Northwest. Another is the Condit Dam, constructed in 1912 and created what was known as Northwestern Lake on the White Salmon River, generated about 15 megawatts of electricity. Pacificor held the FERC license for this facility. The dam received its first federal license to operate under the FPA in 1968, when the Supreme Court actually concluded that the FPA reached non-navigable tributaries to navigable waters. There was some debate over Condit for a while, whether or not it was subject to FERC's jurisdiction or not. So in 1996, FERC issued an order requiring Pacificor to construct permanent fish passage facilities, making the continued operation of the dam uneconomical. And by 2006, there was still a little bit of an open question in 96, but by 2006, we have a holding from the DC Circuit that FERC is not required to issue a license that guarantees the project will be profitable. So FERC can put conditions on a license that then make that project unprofitable. So in 1999, there was a settlement agreement between Pacificor and the other parties to the relicensing that resulted in a decision to remove this facility. We get a little explosion on this. This one is a little time lapse, but actually not much. This is over a matter of hours that this happened. I love that line, and sure enough, there was the river. These rivers know what to do when let free. This is the reservoir site, just to give you a sense, in the summer of 2012. You can see the river canyon re-emerging and the land that was near the reservoir. One of the dynamics around the removal of conduit was there were a bunch of people who had really nice cabins along Northwestern Lake who don't have a lakeside cabin anymore. You can see where the reservoir was. As part of the settlement, this was all part of the dynamic that was worked out. You can also imagine when you look at those pictures of the removal, there were all kinds of issues around Clean Water Act compliance and protection for endangered species when you see that incredible volume of settlement passed down through the reservoir. So the taking out of a dam is its own regulatory and process for making sure it comes out in a way that is responsible. This is just another shot of the canyon in 2003. There are efforts to do revegetation and planting of native plants to restore the riparian corridor here where the reservoir once stood. And then one more, the largest, when conduit was removed, it was the largest in the United States. This past summer, 2 summers ago, the Elwha dams began to come out on the Elwha River in Washington, also the result of a FERC relicensing. The Glines Canyon Dam in particular was constructed in 1925. It was the second of 2 dams on the Elwha River. It received a 50-year permit under the Federal Power Act in 1926. It was a hydropower facility, and between it and the other dam generated about 29 megawatts. In 1938, Olympic National Park was created and included Lake Mills and the Glen Canyon Dam up to the base of Glines Canyon. I always say Glen, sorry. I promise that's not Freudian. Don't put that in the transcript. Olympic National Park was created, and the Glines Canyon Dam was within the boundaries of that park up to the base of the dam. In 1973, the owners submitted an application to relicense this facility. In 1978, the dam failed a safety inspection. And ultimately, this is an amazing story, which I don't have time to tell, but there was federal legislation to purchase and remove the Elwha and Glines Canyon dams. $29.5 million to buy both dams. The estimated cost of the purchase and removal is somewhere between $40 and $60 million. And the total restoration effort on the Elwha watershed is estimated at $351.4 million. And so we can take, this is the last video, I promise, to take a look at the notching, different style of removal. As you'll see, this is time lapse. You can watch the time. This is over a couple of months. You can see the engineering and the engineering approach that was taken with regard to this facility. We're now in January. It's winter. So eventually on this structure, this is a very tall, narrow dam. And so when it gets to the bottom, this method of removal was ineffective at some point. You had still pieces of this at the bottom that had to be blown out. Today, actually, I'll show you the news clip. Today, the last 50 feet of the Glines Canyon Dam is being blown out. It has survived the federal shutdown because the dollars have already been appropriated. And so they're actually moving forward with the last explosion of the last 50 feet. This is the former Lake Mills this September. So this is where the lake was. You see the river returning to its channel. The braiding of the river channel, you begin to see, this is October, just in October, Lower Lake Mills. Another one from October. And then this one, which is really astounding, an aerial view of where the reservoir was and where the river channel is returning to in Washington. And then the story. So the explosion, I found this last night, which sort of made me think, well, good omen, I guess. So the last piece of the Elwha Dam will come out today, 50 feet, if all goes as planned. So let's now, those are the success stories. And I think success stories, from the perspective, I mean, you'll have other speakers today who represent the hydropower industry and, representatives from Pacific Corp. These are situations where the parties have agreed to do this. None of these are the result of a federal court decision to take a, dam out. There have been legal decisions along the way, administrative decisions, but these are not controversial like that. They've been controversial, but they're places where we have come to an agreement through this relicensing process, through this process of taking a second look to evaluate the impacts of some of these facilities. The Elwha is the largest one to date in the United States. It shrinks in comparison to the proposal that is on the table for the Klamath River Basin. Before talking about Klamath, I want to give the dam removal part, I want to give a little background just on this basin. Southern Oregon, Northern California, the scene of my entire legal career has played itself out in the context of this basin, so I can go on and on about this basin. I started work on this in the year 2000 When I just graduated from law school in 1998. I clerked for a year, and then I went to work at the Department of Interior, and they handed me Klamath. Unbelievable to represent the Fish and Wildlife Service in the context of this. In 2001, for those of you who know the story, there was a decision for the first time in the United States to shut down Bureau of Reclamation irrigation project through the operation of the Endangered Species Act and to release flows for an asserted tribal fisheries right. It was a very dramatic year, an awful year for the farmers in the Klamath irrigation project. Without water, the loans couldn't be made, livelihoods were destroyed. The dynamics in the basin were unbelievable. The center of the dispute was at the A Canal, which is the canal that diverts water out of the Link River into the Klamath irrigation project. It's hard to even describe, I think, what was going on at the A Canal. There was civil disobedience. There were folks who were opening the canal after the Bureau of Reclamation shut it down. At one point, the United States posted U.S. Marshals at the A Canal to keep the A Canal closed. Local law enforcement refused to enforce the closure order on the A Canal. There was a cavalry at one point. It ultimately resulted in what was called the Bucket Brigade. It was the largest civil demonstration in Klamath, I think, that Klamath Falls has ever seen. The Bucket Brigade carried water out of the lake, around the A headgate, and into the canals, into the project, through downtown Klamath Falls, and then ultimately into the A Canal. It was the largest, as you can see here. Folks came in from all over the country to participate in the protests associated with the shutdown of this project. Ultimately, later in the summer of 2001, Secretary Gail Norton at the time reopened the headgate. It was essentially too late for that irrigation season. But then in 2002, under very similar water conditions, hydrologic conditions, a decision was made to provide irrigation water to the project rather than shut the A headgate down. After going through what happened in 2001, I can see why you might decide to release the water the next year. And then for those of you who know, 2002 is the largest fish kill in U.S. history. And so it just is a perfect, 1 year the burden fell on the project irrigators, and the next year the burden fell on those who rely on the fishery. Just to set a little context, when all of this was happening, we have an ongoing state general stream adjudication where folks are asserting water rights. We don't yet know who has what water rights. The state of Oregon, without a decree, will not enforce water rights. The Klamath tribes have pursued their water rights both in the context of the state adjudication and in federal court. As a result of the 2001 shutdown and the 2002 fish kill, there are lawsuits pending in federal court challenging both of those administrative decisions. In 2005, we actually get a Fifth Amendment takings litigation filed on behalf of the water users, asserting that the regulatory action resulted in the taking of their water rights. And in the midst of all of this, guess what we start doing? Pacificor gets to start a relicensing process on the 4 dams that represent the southernmost, the lowest blockage to fish passage on the Klamath River, downstream of the actual irrigation project. In addition to those dynamics, we also have the politicization of the science associated with all of this work that's being done in the Klamath Basin. There's a National Academy of Sciences review in 2002 of the decision in 2001 that results in new biological opinions for the sucker and the coho, the 2 fish species. And it really highlights for people the difference between the National Academy's standards around science and the ESA standards, which are best available, and really throws into tension what the ESA asks those agencies to do, which is rely not on the best science available, but the best science, but the best available science. And then in 2003 and 2007, we go through this time of lots of reports in newspapers, in the New York Times and the Washington Post, about political interference with the scientific decisions that were made associated with the Klamath. And so all of this is happening in the context of Pacificor also being in the middle of a relicensing. With regard to Pacificor and federal hydropower dams on this system, the Klamath project is up here. This is Upper Klamath Lake. The irrigation project actually sits right in here around the town of Klamath Falls. The FERC dams are downstream, and there are 4 of those dams downstream. Iron Gate Dam, Cupco 1, Cupco 2, and J.C. Boyle. And these are the dams that are subject to the relicensing proceeding. So Pacificor starts the process. In 2004, there's some new scientific data that where federal scientists are concluding that salmon formerly spawned in the upper basin up past these facilities. In the spring of 2006, the federal agencies submit conditions and prescriptions that call for a different kind of fish passage at these facilities. In the middle of all of this, we also have the Energy Policy Act of 2005, which many people thought was, and I agree with them, really hurts the relicensing process on behalf of those that are trying to get dams taken out. In Klamath, it had a really different effect. The Energy Policy Act allows parties to ask for a hearing, an administrative hearing, to challenge the material facts associated with the conditions and prescriptions. And Pacificor requests one of those hearings, and we have an administrative proceeding to evaluate the conditions and prescriptions that have been submitted by the agencies. Ultimately, Judge McKenna, in that administrative proceeding, ends up upholding 12 of the 14 conditions and prescriptions that are submitted. And then ultimately, FERC rejects the trap and haul solution to the salmon problem and orders Pacificor to build fish ladders at the 4 Klamath dams. That then sets the stage for what is the Klamath Basin Restoration Agreement, I believe, because it means that Pacificor is now making a business decision about the cost of, I don't work for Pacificor, so I don't know. I suspect they were in rooms saying to themselves, okay, wait a minute. The cost of what we're going to have to do to get these dams relicensed, it doesn't make sense in light of the hydropower they're generating and the money we're making. And I suspect they were also thinking about it in the context of this larger fight that was going on in the Klamath Basin. Nothing was going to move in the Klamath Basin, I don't think, until somebody pulled their interests off the table, right? And that is what Pacificor was able to do. When Pacificor comes to the negotiating table and says, okay, we're ready to talk about what it would mean to take out the 4 lower dams, the dynamics of the negotiation change, and we set the stage for the settlement agreement. The settlement agreement that all the parties, the negotiating parties in the basin signed, has a sub-agreement around the hydropower piece, and that calls for the dams to be removed after careful study. That's called the Klamath Hydropower Settlement Agreement. Salmon and steelhead to be reintroduced to the basin. Water for ag is limited but secure. The off-project irrigators are to meet performance standards. Irrigators continue to get affordable electricity, and the Klamath tribes secure land in exchange for reducing water rights claims in the adjudication. Now, there are plenty of critics of this settlement agreement, and I could give a separate presentation on whether or not this is a good settlement agreement or not. What I want to focus on today is the fact that it is the relicensing process that unlocked the potential for this kind of agreement to come into place. The cost of the dam removal is estimated at $450 million. If it goes above, the agreement provides a release from liability for the states of California, Oregon, and Pacificor. And the burden then falls on the federal government or private supporters. And where does the $450 million come from? It comes from Pacificor ratepayers and Oregon and California taxpayers from state support to take those facilities out. In 2010, the governors of Oregon and California and the Secretary of Interior signed a lovely agreement, had a photo op saying this is what they wanted to do. But let's talk about what's really going on with the agreement today. Where does it stand? The Secretary of Interior was to make a determination about dam removal. After that determination was made, the project would proceed only if Congress enacted legislation approving the entire KBRA, Klamath Basin Restoration Agreement and Settlement, which was another $400 million. That does put the price tag of this project at $850 million now, if anybody's keeping track. And the Secretary and Pacific Corps agree to transfer title of the dams, and the states authorize the funding for removal, and the Secretary identifies a willing dam removal entity. Those are a lot of ands, and that's where the agreement stands. Ken Salazar, before leaving as Secretary of the Interior, indicated that he could not make the final dam removal decision until Congress had appropriated the funds. I don't know if any of you are following what's going on in Congress right now, but the chance of appropriating $850 million right now for a dam removal project in a tiny basin in southern Oregon and northern California, important to all of us, maybe not as significant to everybody else, is a hard sell in the legislature. Wyden and Merkley and Kitzhaber have actually created a task force, and that task force is bringing the parties together again to talk about reducing the cost of the settlement agreement. So that's where we stand. I'm not dismayed, however, about standing here, because I think for those who worked on the Elwha and the Condit and other dam removal projects in the U.S., they know that there were doubtful moments along the way where it looked like the political landscape was not going to result in a dam removal. There has been astounding work done here. And remember that if this agreement doesn't go through, we still have a federal licensee that has an order from FERC to put in fish ladders that make the business proposition of those facilities very difficult. So even if this entire settlement goes away, the question of the dam removal on those 4 facilities is still a live one through this regulatory and legal process that's created under the Federal Power Act. So we fall back to that process and start again. So what is this new era that we're ushering in? I think there is pressure to generate more green power. Hydropower. There are impacts to that generation capacity. There are efforts to retrofit existing facilities that make sense to still have in place to make sure they're producing hydropower. I think the role of the FERC process is the game in dam removal in the United States right now. It's where the action is. It's where I think the action will continue to be for quite some time. That is in stark contrast to the larger federally owned dams and the likelihood that we will experience serious dam removal proposals in that context. I do not believe we will because of what that requires. The driver on these facilities is compliance with the ESA, and there's not a time-limited license. And so we're just, I just don't think we're going to see the removal proposals be as profound. It also, those processes do not provide for citizen participation in the way that the Federal Power Act does. The 2 big drivers outside of the Federal Power Act on rivers are the Endangered Species Act, which is essentially a Section 7 consultation between an action agency and the consulting agency. And, citizens can comment and sort of bite around the edges and file a lawsuit once it's all over. There's not the kind of meaningful citizen participation that you have in the Federal Power Act process. Or the general stream adjudication. And the general stream adjudication is limited to those who hold water rights. And so if you're a citizen and you don't hold a water right, it's very difficult to impact the dynamics on a river in the context of that general stream adjudication. The Federal Power Act and the relicensing process represents a very different kind of way for folks to engage. And then the other dynamic that is ever present in these projects is the role of financing from public sources. And the dynamics for most of these license holders is whether or not they take, what their liability is for taking these facilities out and dealing with what might lay behind there. So while we have increased interest and demand for hydropower as a lower carbon source of energy and a gap-filling source of energy for other renewables, that demand is tempered by the recognition of the value of our river ecosystems and bounded by a regulatory process that allows society to take a second look at the kinds of trade-offs we're making. And so it makes me think that we may actually be embodying the wisdom of our own Northwest Supreme Court Justice, William O. Douglas, when he said, in considering the High Mountain Sheep Project, pump storage project at the confluence of the Snake and Columbia Rivers, that the importance of salmon and steelhead in our outdoor life, as well as in commerce, is so great that there certainly comes a time when their destruction might necessitate a halt in so-called improvements and developments of our waterways. The destruction of anadromous fish in our western waters is so notorious that we cannot believe that Congress, through the present act," he's referring to the Federal Power Act, "authorized their ultimate demise. As Mr. Justice Holmes once wrote, a river is more than an amenity, it's a treasure." Thank you so much. Yeah, and so I'm happy to take questions. That was long. Thank you for indulging. I have a lot to say on this matter. Questions? Yep.
So, where do, once these dams are shut down, either voluntarily or through the regulatory process of actually forcing, not renewing a license, where do those surrounding areas, where are they going to get power from? Like, is it taken into consideration that while these dams might not be as green or functioning to these, like, the level that we want them to, the alternative, like what, in comparison to where else is it compared to other sources of energy for the region, and how it can, if those are as green, and how does that?
Yeah, so the relicensing process allows for, has built into it examination of those kinds of issues, right? The power issues, sort of how that relates. So certainly the law envisions and the regulatory process envisions those kinds of inquiries. I think the other place that those kind of inquiries end up happening too are a function of the sort of business and market decisions that the licensees are facing, right? So I don't know because I have never represented a licensee. I've only been on the other side of that equation, but I suspect that it's causing licensees, sort of private hydropower developers, to think about what it means to retrofit facilities that produce more power and get more power out of them to put in the market and take other facilities out. I think it's reorienting. I think you're going to hear from some speakers later today who may actually be able to answer this better than I. It's sort of reorienting a licensee's way of looking at the hydropower resource on the whole. And licensees together to look at that entire hydropower resource rather than focusing it on, this dam and this dam and this dam, right? And sort of making a more holistic judgment about where does it make sense to have facilities, and are we getting as much hydropower as we can out of those facilities? Sort of a smart growth kind of model around those facilities. But that pressure is real. And with the presence of renewable energy standards and portfolios that states are being forced to meet, that are also good things for the environment and the situation we face with climate change. Those pressures and dynamics around which come out are very real and very present. So please don't hear me in talking about this to be saying we're getting ready to take out all of our hydropower dams. That's not happening. What we are ushering in is an era where we're taking a second look, and when we're taking that second look, environmental considerations and impacts to fisheries and habitats are at that table in the same way that some of those other questions are. And I just don't see that in this way anyplace else in the law. It's why the Federal Power Act is one of my favorite statutes, and I never thought I would say that. It's an amazing thing what is happening under this relicensing process in under the Federal Power Act. And it's in this, it's in the Department of Energy, in this agency this commission known as FERC. Who would have thought that that's where, this restoration work, that was the sort of locus of this kind of work. Yep.
The environmental impacts of removing a dam ever prevented the removal of the dam?
That's a great question. I don't actually know if it's ever prevented the removal. I know certainly with regard to the study of dam removal on the Klamath dams, there are some very serious environmental concerns, including the toxicity, I guess is the right way to say it, you may have a different, of the sediment that's accumulated behind the dams. And things like the impact of that sediment release on the downstream fishery. If you watch the longer video on Condent, part of dam deconstruction is another whole process that involves NEPA and Section 7 compliance and Clean Water Act compliance. Just because it's overall a positive thing for the environment, it still triggers all of those statutes. And so it's the process of actually taking one out is as robust as the process of putting one in, I think, in terms of evaluating those impacts. And so in that Condet video, which I encourage you to go watch, they gathered up all the salmon beforehand before they blew it in order to, try to protect them. That, lots of trap and haul operations going on in order to try to have the least amount of environmental impact in the deconstruction process. There's a lot of fine legal work being done around, all of those compliance efforts in the deconstruction process as well. It's no small feat. I mean, when you see some of those videos, it's no small engineering feat, and it's no small feat in terms of environmental compliance as well to do that work. Yep.
What kind of impact does this have on the beautification of basins, and what happens to these non-consumptive rights that these dams might have?
Right. So that is a great question, and somebody should write a paper on that. There are, sometimes there are water rights, storage rights associated with these facilities, and so there's a whole question about when that reservoir isn't there anymore, where do those storage rights go? Oregon law, and that's going to be a function of state law in most cases because the licensees have secured the necessary water rights under state water law. Everybody who's here from water law should know that at this point. If you don't, come and talk to me. So it depends on what state law says oftentimes if they are state-based water rights. Oregon's water code has this interesting provision about those rights potentially reverting to in-stream flow. And becoming in-stream flow provisions. It's something that somebody really should write a paper on, that provision of Oregon law, particularly as we face some of these. And you may have more information now.
I was going to say, I actually used to work for the Water Resources Department. Right, that section. That's very much talks about. There is a provision that looks at when a dam is removed, what happens to the water right, and there's a process that Water Resources goes through to determine how much goes back in stream. And it isn't strictly you just look at the water right and say it's 500 CFS and that goes back in stream. They look at what the project actually used regularly, what other uses were there, and I think overall the attempt is to protect existing uses, even if they're junior uses, and not to essentially disrupt the use of water in the stream. And if I recall correctly, that in-stream right, typically in-stream rights are through a reach.
That's right.
This is the other. But in this case with a hydro project, it really is the single point of diversion. So unless the department, and I think the department's only gone through it once on the Powerdale project, which is a project I worked for Pacific for, and I'll be speaking technically. And that's, I think, the only process, time they've gone through that process to determine the in-stream right. And I believe it's at a point in the stream as opposed to a reach in the stream. Yeah. And so they can actually call water down to that point as an in-stream right.
It is potentially a very powerful in-stream right in terms of protecting the upper reaches above that point of diversion. Yeah. Thank you for writing that. I had no idea. I have spent many an hour looking at that provision and thinking about what to do with that. Great paper topic if somebody's looking for one. And you have a really good source right in the room. Other questions? Yeah.
With the 4 dams on the lower basin of the Klamath, since they haven't been relicensed, so they're not able to operate in the meantime. Is that correct?
No, they operate under annual licenses from FERC. So FERC has a process when we're sort of in the predicament that we're in now for issuing annual licenses with some conditions and requirements on the licensee for what to do so that we don't, the idea is that we don't make it worse while we're trying to figure out if we can take them out, So it's an annual process that the licensee goes through. Yeah.
And kind of a related question was once funding somehow gets appropriated for the decommissioning, are there any other hang-ups or issues that need to be resolved before they start decommissioning?
I'm sure there will be. What's interesting is I think for the For the parties who don't like the KBRA and don't believe it was an appropriate settlement for the conflict in the basin, I'm seeing an upsurge in sort of efforts to kind of revisit the whole agreement. I mean, what's really interesting about Klamath now is that you have an agreement about removing a set of dams that's sort of embedded in a larger settlement of water rights questions, land tenure questions, ESA questions, power questions. It's all embedded in this larger agreement. I don't think we've seen that before in this setup. And so, each negotiating party's interests in, everybody has their interest in which piece of the agreement they like or dislike, and it has a lot of moving parts. So I don't know that if $850 million suddenly came through, I think everybody who's involved with Klamath is sort of a little on pins and needles about whether the agreement will hold in the face of this lapse of time. We had a very difficult water year in the Klamath Basin this summer, for those of you who followed it. And I think, jury's still out on whether all the parties are still holding to the agreement with the lack of appropriations. The removal of those dams, and you might be able to speak to this more as well, it will be the biggest project ever. There are 4 of them. It is, the engineering that will go into it and the sort of environmental impacts that'll have to be studied as a result of it are bigger than anything we've done before. So I don't know that if tomorrow Congress appropriated $850 million for this, that we'd be out of the woods. I know that the study that the Secretary did, though, to make the secretarial determination, laid out a path for moving forward with dam removal. So it's not that it's serious. I mean, the proposal is serious, and that path was set forth. Ultimately, the Secretary decided he was unable to sign it until Congress had appropriated the money. And that was part law, part politics. I was not there for it, so I didn't advise on it. I saw it coming, though. So it's, yeah. Other questions? Yeah, Brian.
So, a FERC hydropower license must be in the public interest, which is a very vague term. Do you think that as FERC sees it, or as this plays out in front of FERC, that the actual notion of what is in the public interest has changed, or is it a combination of that and that fisheries declines have just gotten more obvious and severe?
I think it's a couple of things. I think, as you know, and if you've taken any class from me, you know that the public interest is a tricky thing, and sometimes it's defined and sometimes it's not. So our walking around definition of what the public interest is can look really different than what Congress or a state legislature says by definition is the public interest, right? So one of the most powerful things in terms of the Federal Power Act were the 86 amendments that helped define what the public interest was, right? This is very significant because Congress said, FERC, when you are examining this license or this relicense, you have to give equal consideration to these things. And by defining what needed to be given equal consideration, you defined essentially what that public interest looks like. So you bound that agency to this standard. In admin law, we talk about how sometimes Congress passes statutes that are so wide open and meaningless that it gives the agency so much discretion the agency can be anywhere it wants to be, right? That's not the case here. There are some bounds on that discretion. So that's one thing that's happened. The other thing that's happened is just the simple fact of having to take a second look, the relicensing process, the way the larger framework of the regulatory structure is built, it sort of forces us to come back to the table. It's not a decision that's locked in place. And so when that happens, you have these kinds of provisions, and then you add to that this astounding authority of conditions and prescriptions that other agencies can apply that are mandatory on the license. Suddenly the way you're evaluating one of these opens really wide up and ultimately informs the business decision that any licensee is making, right? It's kind of a beautiful regulatory structure. A lot of people hate it, but I get to have the law professor's perspective. It's sort of amazing. It's a regulatory structure that I think begins to get at what society wants and expects from these facilities, right? It's not a law that mandates dam removal. It's not a law that mandates dam construction. It's a law that actually sets the table in a way that we can make what I hope are more informed and responsible decisions. So that drives it as well. You know, the licensee at some point says, you know what, what are we fighting for here, right? And so the market and the business decision is allowed to enter the decision-making space as well. And so I think that helps inform it. Yep, Christina.
Where do you stand on like the timeline for most of these projects? Are we just getting into most of our second looks, or most of those passed?
We're about, somebody in the room probably knows, we're well into it. We're sort of nearing, I think, one of the final stage of this. Yeah, one of you probably know better.
Yeah, I think, FERC has, they call them classes. And
Yeah.
we're, I think through essentially the second big class. So most of the large project FERC relicensing is over or nearly over. They have some of the smaller projects out there, but I think the bulk of the big relicensings are either over or well underway. You know, projects like the Klamath can stretch on for a long time. A standard FERC relicensing is about 6 years. You have to start 5.5 years out before your license expires. Most utilities or projects will start long before that, doing some of their environmental studies. And then, as I think probably every project you mentioned there, went past their license expiration and operated on annual licenses until there was an ultimate outcome.
Yeah. But there are some left, and there's some really interesting developments. This is a awful word for some people, but there's the whole reopener question. With new, as new information comes online, what does a reopener of a license look like? And we're not well settled on that, but yeah.
There's also a lot that happens within implementation.
That's right.
So that's
Yep.
a whole nother.
So then once the license, if the license is reauthorized, regranted, the project is operational, that project may now be operational with a whole set of conditions and prescriptions and things that it has to do. So there's a whole body of work around making sure the facility then is operating consistent with that. Other questions? Yes.
I was struck by the cost of decommissioning.
Yes.
Over $20 million for the Marmot Dam. I mean, it feel like that project was done in one day.
Yeah.
What cost $25 million size lawyers?
So a lot of lawyers, I'm sure. I think, others may be able to answer this question better than I in terms of what the costs associated with it are. I'm most familiar with the costs associated with Klamath. 850 million, and I'll tell you, I give another whole presentation. Nothing aggravates me more, actually, than when, and many of you have heard me say this, when everybody says, oh, look, all the parties came together in a stakeholder-based negotiation in the Klamath Basin, and they settled it. See what can happen when we all come together and we get along. And I'm like, and you agree that the federal government will contribute $850 million. I can settle a lot of things with $850 million of not my own money, right? I mean, think about that for a minute. Those parties came together and negotiated about the federal government providing $850 million, right? So they were able to reach agreement. So part of the cost associated with that deal is buying out water rights and providing other sources of cheap electricity and subsidizing, there's all kinds of intricacies in that agreement. So part of that settlement, at least the one I'm the most familiar with, the cost is associated with, that's the kind of conflict that is. And to get people to move off of what they believe their solid legal positions are will take a lot of money. And the question is, is there $850 million out there that the public is willing to spend to resolve that conflict? Right, that particular conflict, but it is on the backs of, taxpayers and ratepayers. Taxpayers and ratepayers, really, that settlement. So, but great question. I suspect all the settlements have those dynamics, just in a smaller form, right? So it was the same thing. There were people that had, there were ways money had to be spent. There were studies that had to be done. There was scientific work and engineering work that has to be done to pull that off. That it's very expensive. You know, one of the controversial things is, what is the share of the decommissioning cost that should be borne by the licensee? And that's why that 1994 statement out of FERC about the, you know, it's why the word normally and anticipated and reasonable got thrown in there, right? Because you don't want to create a disincentive where the cost of taking one out is so expensive to the licensee that it actually makes more sense for them to run, to run a bad facility, when they should be taking it out. But at the same time, the licensee is also the sort of business entity that has benefited from that dam and made a profit because of that use of that public, what I would call a public resource. And so, there's a lot of controversy inside that question of liability. I think that for licensees, the game becomes, once a licensee makes a decision that decommissioning is appropriate, that doesn't make business sense to proceed, I think the plan becomes figuring out how to keep the liability for that decommissioning the lowest, right? How can we build a coalition and a set of negotiators and a set of supporters and constituents that will support, help us support financing this some other way than out of the coffers of that licensee. I think that's where I think for licensees, that's what happens. I suspect that Pacificor, it might be the most interested party in seeing the KBRE go forward, right? I mean, they have a huge interest in this larger settlement holding. I don't know that for sure, but if I were guessing, I would guess that they have a pretty deep interest in that agreement holding. I think I'm probably at the end of my time. I'll let you all govern that. Okay, thank you very much.